at page 131 of volume 1. It is a letter dated 24th of June 2017. And my Lord, because this is an important letter, I'll just refer to the second paragraph where he says, in accordance with section 14 of the Election Offences Act, which is the allegation made by the petitioner, the Commission published notice in the press advising candidates against the use of public resources in campaigns. A copy of the notice is enclosed. And then he says that following that publication, the Commission has received declaration from only 12 people. In that regard, any other person using state resources other than those registered with the Commission are committing offences to which, upon sufficient evidence being gathered, should be prosecuted swiftly. And my Lord, the Director of Public Prosecution, at the letter at page 135, acknowledged receipt of that letter from the second respondent and referred the issue to the Director of Criminal Investigations for his further action. And that letter, my Lord, you'll find it at page 136. Since, my Lord, the allegations that are being made were in the nature of a criminal offense, the only person with the power to investigate and take action in connection with that issue is the Director of Public Prosecution. And therefore, the issue was directed to the correct person. So it's not true to say that the second respondent or the first and second respondent did not do anything when this issue was raised with them. My Lord, the other issue that has been raised regarding the conduct of the elections is regarding the late opening of stations. And you'll find this, my Lord, in the affidavit of Moses Wamuru. But before I go there, my Lord, may I first deal with the question of names of voters who are missing from the register of KIMS in Migori, Homa Bay, and Kisumu counties. And this is set out in the affidavit of Olga Karani. My Lord, these allegations are not true for two reasons. First of all, in her affidavit, my Lord, Olga Karani confirms that she voted in Westlands. She was not in Kisumu. She was not in Migori. She then does not say who are these people whose names were not in the register. There is no affidavit from anyone in those stations saying, I went to vote and did not find my name in the register. So that the allegation being made by Olga is at best hearsay. She does not lay a foundation for it. She does not say where she got this information from. It is untrue. The other affidavit, my Lord, and I want to spend a bit of time on it, is the affidavit of Moses Wamuru. My Lord, this affidavit is sensational in several characters. First of all, my Lord, the agent describes himself as an agent of the NASA party. My Lord, when you retire to make your decision, you will notice that NASA is not a political party. And this is contained in the affidavit of Lucy Ndungu, the Registrar of Political Parties. It is a coalition of political parties. It cannot appoint agents under Regulation 79. And so, my Lord, first of all, the capacity of this person to swear the affidavit is doubtful. But secondly, my Lord, while she talks about certain agents having been denied access, first, she doesn't give the names of these alleged agents. There's no name given. There is no affidavit from these alleged people saying that they were denied access. And so, at best, that allegation, my Lord, again, is hearsay. It's inadmissible. My Lord, the response to that, you'll find it in the affidavit of Lucy Ndungu, the Registrar of Political Parties. You'll find it at page 286 of volume 2, where she deals with this issue. There are also several affidavits, my Lord, that have been filed to deal with the allegations of agents being thrown out of polling stations. And I'll just name them quickly for purposes of saving on time. There is the affidavit of Dolly Josephine Mudhanje. You'll find it at page 379 to 393 of volume 2. You'll also find the affidavit of Ezekiel Mugendi Ireri. It's at page 394 to 415 of volume 2. Affidavit of Faith Mugo at page 416 to 422 of volume 2. Affidavit of Amina Shaku Jaso at page 423 to 478 of volume 2. And then affidavit of Henry Kaduri Njue at page 479 of volume 2. affidavit of Robert Kinyua Peter at page 498, affidavit of Jack Lewis Mureithi at page 518, affidavit of Consolata Mothoni at page 534, affidavit of Ephantas Nyaga at page 604, affidavit of Daniel Namunjagi at page 618, and affidavit of Pamela Karemi at page 632. Then there is also the affidavit of David Mureithi Ngondi at page 637. All these individuals confirm that not a single person was ejected from any polling station. Now, my lord, this is also confirmed in the IGAD Election Observer Mission report, which you'll find at page 378 of volume 1, where, my lord, they comment that party agents were evident in large numbers due to the number of political parties contesting these elections, which was commendable as it allowed for a high degree of transparency and oversight over the process. Party agents were also very present and are assessed to be able to operate freely. The EOM, as well as candidate agents and citizen observers, were able to observe the voting process without restriction. This is an independent report that has been given by observers, which contradicts in material aspects an affidavit that has been sworn by one person, my lord, who, as we have indicated, does not even say who are these people that were being removed from polling stations. My lord, the other issue that was raised is that some polling stations had more than 700 registered voters and an abnormally high number of rejected votes. Again, you will find, my lord, this is a bare assertion that was made by the petitioner, and it's contained in the affidavit of Moses Wamuru, Olga, and April. And the specific areas referred to are Karicha Primary School, which they say recorded more than 100% at the Tallying Center. First of all, my lord, as explained by my learned friend, Mr. Nyamodi, the KIMS kits were configured in such a way that they could not allow registration or voting by more than 700 people. That is how the KIMS gadget was configured. And there is no contradiction that has been raised on that issue. And the KIMS system could not allow more voters than those provided for in the specific polling station. So that the allegation that in certain stations more voters than those registered were recorded is not true. And my lord, this is also captured in paragraph 41 of the affidavit of Immaculate Kasait. My lord, the other allegation that was made is that paragraph 16 of the affidavit of Moses Wamuru is that agents were kept out of counting halls when they, and that when they noticed the presiding officers were counting rejected votes in favor of the third respondent. My lord, again, this allegation is absolutely not true. First of all, there are no specific particulars that have been given regarding the stations that this was allegedly happening at. My lord, the returning officer for Runyenjes has sworn an affidavit. You'll see it at page 423, at paragraph 17, and he confirms that it's not true that during the counting, presiding officers were counting rejected votes. My lord, the EU mission, again, on this issue, and you'll find this at page 370 of volume 1, comments that overall closing and counting was well conducted with good levels of transparency and in the presence of candidate representatives and observers without interference. This is a confirmation, again, by an independent observer mission. My lord, the IGAD Election Observer Mission at page 378 of volume 1 also commented that at the close of polls at 1700 hours, the majority of polling stations had a small number of remaining voters or no queues. All our teams deployed reported that the polls closed peacefully in their respective location and that the counts were conducted efficiently and transparently. This, my lord, belies the allegation made by the petitioner. My lord, the issue of the timing of the return of the ballots has been dealt with by my learned friend, and I do not wish to comment on that at all. My lord, the only issue that I wish to now take up, my lord, is regarding the law concerning these issues. My lord, there is the issue that was made that the Communication Authority of Kenya had advised the petition, the first respondent, not to use the cloud system in transmission in server. This you'll find, my lord, there is a letter you'll find at page 413 of volume 1, which is a letter from the Communication Authority of Kenya, which says it is actually satisfied and gave the go-ahead for the first respondent to use the cloud, so that that allegation is not true. And so, my Lord, in a situation such as this, where these allegations are being made, and we have shown, my Lord, that they are not true, what is the court to do in such circumstances? My Lord, I just wish to refer you to two authorities. The first one, my Lord, is the case of Opis versus Zenoski. It's a 2012 decision, my Lord, the Canadian Supreme Court. And, my Lord, on point number 2, the court had this to say, my Lord. At issue in this appeal are the principles to be applied when a federal election is challenged on the basis of irregularities. Those few items, my Lord, that were pointed out. We are dealing here with a challenge based on administrative errors, just like in this case. There is no allegation of fraud, corruption, or illegal practices because we have shown those are not true. Given the complexity of administering a federal election, the tens of thousands of election workers involved, many of whom have no on-the-job experience, and the short time frame for hiring and training them, it is inevitable that administrative mistakes will be made. If election can be easily annulled on the basis of administrative errors, public confidence in the finality and legitimacy of election results will be eroded. Only irregularities that affect the result of the election and thereby undermine the integrity of the electoral process are grounds for overturning an election. The balance struck by the Act reflects the fact that our electoral system must balance several interrelated and sometimes conflicting values. Those values include certainty, accuracy, fairness, accessibility, voter anonymity, promptness, finality, legitimacy, efficiency, and cost. But the central value is the charter-protected right to vote, so that the right to vote is central to the determination that the court must make on this issue. And the practical realities of election administration are such that imperfections in the conduct of elections are inevitable. So that the fact, my Lord, that you have been told there were arithmetic errors that were made, which some of the returning officers have confirmed, cannot be a basis for vitiating an election once it is shown that the process that was carried out was an election in terms of Article 86 of the Constitution. My Lord, the only other decision I wish to refer you is the Rally for Democracy and Progress and 8 others versus the Election Commission of Namibia and 5 others. And what that court, my Lord, says, an immediate decision, is that in the absence of any evidence that a result different to any of those announced at polling stations was used, this complaint must fail. The administrative mistakes made by the presiding officers who completed the returns in question undoubtedly bears on the checks and balances. However, when considered against the total number of polling stations and the ballots cast in the National Assembly election, those errors, preventable as they were, are not so serious that they are detracted from or diminished that or any of the principles in accordance with which the National Assembly election had to be conducted. We are also satisfied, and this follows from our earlier finding, that the first respondent has proven on balance of probability the result of National Assembly election was not affected by the mistakes, which is the case that applies in the circumstances of this case. And so, my Lord, based on those submissions, we urge, my Lords, to find that the petitioners in this case have not proven their case, and urge you to dismiss the same with cause. That's all.
Thank you very much, Mr. Karoli. Thank you very much.
Yes, my Lord,
yes.
My ladies, I have 15 minutes to address you. Yes, 15 minutes to address you on burden and standard of proof in election petitions. Now, Your Lordship, the Chief Justice, when you asked my learned friend about the Seychelles decision, he did not tell you, he did not respond. And you recall, my lords, ladies, in 2013, you relied on a decision from the Seychelles courts, the Constitutional Court, that addressed the issue of rejected votes. And you preferred, after a lot of investigation on the matter, you preferred the minority decision. Now, of course, a lot has been written about that. But then what did happen subsequently? The Court of Appeal upheld the decision of the Constitutional Court. Subsequently, the Supreme Court our Supreme Court has been cited with approval in yet another decision over that very issue. Now, the reason I say this is because our learned friends have asked you to depart from what we consider to be completely well settled, the law on burden and standard of proof. And I recall all of us at the University of Nairobi were taught about autochthony. I don't know whether it's Professor Kibwana taught us about autochthony. Now, autochthony, we were told, is of an inhabitant of a place indigenous rather than descended from migrants or colonists, which means even if we can track Section 83 backwards to some English legislation, including, my lords, my ladies, the National Assembly and Presidential Elections Act, which we've already repealed, but we have found a decision that works well for our jurisdiction. And as Kenya, we must build our jurisprudence. It cannot be that we always backtrack. Stuck, of course, as already we are with the reception clause, but how far shall we take this? Now, my lords, and since that is settled, I just want to go through the Raila decision of 2013 and remind us, restate for us, even as counsel, what you said about the subject. You said, and again, not to mention that there is already a judiciary bench book on election disputes resolution 2017, and I have taken time to read about the standard and burden of proof that is set in that book that is going to seek, that is going to guide the determination of election disputes during this environment. And again, the Raila decision is cited as the authority that settles the matter on the issue. My lords, my ladies, when you look at paragraph 187 of your decision 2013, you looked at the Zambian case of Lewanika, and you said that high standards of proof are required in cases imputing election malpractice, and that appears to be the norm. Now, that is an African jurisdiction, and we celebrate that one. In paragraph 191, you then say, comparative judicial practice on the burden of proof helps to illuminate this court's perceptions in a case which rests to a significant degree on fact. And you looked at the Kizza Besigye case and you cited it with approval and said the burden of proof in election petitions, as in other civil cases, is settled. It relies on the petitioner to prove his case to the satisfaction of the court. The only controversy surrounds the standard of proof required to satisfy the court. And my Lord, the Chief Justice, you asked my learned friends time and time and time again, what is this variance? You have not been told. But that's a fact. That variance that we have not been told about, that tells us that the result is not what it ought to be, is very, very key to the determination by this court of this matter. Paragraph 192, this is the Canadian case of Opis that has been cited by my learned friend here. An applicant who seeks to annul an election bears the legal burden of proof throughout. Paragraph 193, my lords, my ladies, you looked at the case of Buhari and Obasanjo, and you said the burden is on petitioners to prove that non-compliance has not only taken place, but also has substantially affected the result. There must be clear evidence of non-compliance, then that non-compliance has substantially affected the election. He who asserts is required to prove such fact by adducing credible evidence. On the other hand, if the party succeeds in adducing evidence to prove the pleaded fact, it is said to have discharged the burden of proof that rests on it. The burden is then said to have shifted to the party's adversary to prove that the fact established by the evidence adduced could not, on the preponderance of this evidence, result in the court giving judgment in favor of the party. And my learned colleagues here on the side of the first and second respondents have taken through what had been said to be strong indications of what went wrong with this election, including ungazetted polling stations. I need not go into that. We have discharged that evidential burden of proof, if indeed it even shifted in the first place, because we've already shown that no particulars have even been given to some of the wild allegations that have even been made, including someone said to be a party agent who doesn't seem to have reported those transgressions in Embu County to any police station. The IEBC obviously never heard of it because the IEBC even responded to rumors they never heard until this petition happened that voters were ejected out of polling stations. In the case of Ibrahim Shagari again, which your lordships relied on in coming to this very clear determination and settled law, you said the court is a sole judge, and if it is satisfied that the election has been conducted substantially in accordance with Part 2 of the Act, it will not invalidate it. The wording of Section 123 is such that it presumes that there will be some minor breaches of regulations, but the election will only be avoided if the non-compliance so resulting and established in court by credible evidence is substantial. Further, the court will take into account the effect, if any, which such non-compliance with the provisions of Part 2 of the Electoral Act 1982 has had on the result of the election. My Lord's paragraph 195, again, very sound evaluation of on the point. There is apparently a common thread in the foregoing comparative jurisprudence on burden of proof in election cases. Its essence is that an electoral cause is established much in the same way as a civil cause. The legal burden rests on the petitioner, but depending on the effectiveness, again, you looked at the evidential burden of proof. You said, we find merit in such a judicial approach, as is well exemplified in the several cases from Nigeria, where a party alleges non-conformity with the electoral law, the petitioner must not only prove that there has been non-compliance with the law, but that such failure of compliance did affect the validity of the elections. Then in paragraph 197, you said, IEBC is a constitutional entity, and you said, while it is conceivable that the law of elections can be infringed, especially through incompetence, malpractice, or fraud attributable to the responsible agency, it behoves the person who thus alleges to produce the necessary evidence. Again, my lords, you looked at the case of India, of Mauritius, the Jagnoth case that was mentioned by the petitioners. And because I do not have too much time, I need to get to, yes, of course, you looked at where a standard of proof is required, depending on the specific element in the cause being proved. And then you said some jurisdictions have adopted a standard of proof that goes beyond the balance of probability but falls slightly below, beyond reasonable doubt. And you gave the example of Zambia. And you also looked at the case of Kambela and Mazoka, again, and Patrick Mwanawasa. Then this is really what is important for me to bring before your Lordship. Yes, I'm told time is over. The lesson to be drawn from the several authorities is, in our opinion, that this court should freely determine the standard of proof on the basis of the principles of the Constitution and of its concern to give fulfillment to the safeguarded electoral rights. Judicial practice must not make it burdensome to enforce the principles of properly conducted elections, which give fulfillment to the right of franchise. But at the same time, a petitioner should be under obligation to discharge the initial burden. Now, further on, Your Lordships, you said something very important because you said, in the case of data-specific electoral requirements, such as those specified in Article 138(4) of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt. Now, Your Lordships, you're being asked, in essence, to disturb this particular result under Article 138(4). And yet, that question you asked about variances has been responded to by none of those that have presented the case here on behalf of the petitioners. And therefore, my lords, we are urging you to uphold that well-settled principle on the burden of proof and the standard of proof. And we always say that, you know, judges are men and women of great wisdom. And even if you were to talk about a balance of probabilities or beyond reasonable doubt, it is doubtful that we are able to place in a weighing machine the components of that. In the end, it is to the satisfaction of the court, and we must rest with that wisdom. So I would urge you to uphold that very position. No reason whatsoever, no basis, no rationale given to depart from those very well-settled principles. Thank you very much.
Thank you, Ms. Kaboni. Who is next?
Mr. Wekesa.
My Lord Wekesa.
Yes, Mr.
I'll be submitting for both, for the first respondent, on the question of Section 83 only, which was canvassed here by my learned colleague, Mutaha Kangu. I start my submissions by going back to the Constitution. My lords and my lady, I go to the chapter 7, which has been the premise upon which the petitioners are trying to seek a review of these court decisions in the Raila 2013 case, your judgments as far as Section 83 of the Constitution ought to be looked at again. That decision was also upheld by this same court in the case of Sakari Okoth Obando, and I think also in the case of Katirao Peter Munya. My submission is that if we look at Chapter 7, Section 81, it talks of general principles for the electoral system. There are general principles for an electoral system. Then we go to Section 82, legislation on elections. Then we go to the next sections, the same, even electoral disputes. 871, Parliament shall enact legislation to establish mechanism for timely settling of electoral disputes. The position we want to take is that the Constitution largely leaves the conduct of elections, the mechanics of running an election, to statutory legislation. What the petitioners are trying to do is to use a creative attempt to move away from the dominant legal regime that is at play at the dispute before you, so that they can get relief under the Constitution. The first respondent, though a creature of the Constitution, is set up by an act of Parliament. And every statutory institution conducts its business by interpreting legislation. All the Form 34S, 34B, 34C, these are creatures of statute. The regulations, and now the written law that was set by the court. Our position is that In the majority of the actualization of elections, the first respondent has to interpret statutory legislation. And therefore, it is that premise on which Section 83 is a common position, not just in this jurisdiction, it is the position even in the United States, which has a written constitution as Kenya. But if we look at like the last decision we have referred to in our written submissions, at the end of the submissions, it captures, it's the decision of Bodman versus Esteva, Supreme Court of Florida. It says, we first take note that the real parties in interest here, not in the legal sense, but in realistic terms, are the voters. They are possessed of the ultimate interest, and it is they whom we must give primary consideration. The contestants have direct interest, certainly, but the office they seek is one of high public office, but of outermost importance to the people, thus subordinating their interest to that of the people. Ours is a government of, by, and for the people. Our federal and state constitutions guarantee the right of the people to take an active part in the process of that government, which for the most of our citizens means participation via the election process. The right to vote is the right to participate. It is also the right to speak, but more importantly, the right to be heard. We must tread carefully on that right, or we risk the unnecessary and unjustified muting of the public voice by refusing to recognize an otherwise valid exercise of the right to be a citizen to vote for the sake of sacred and yielding adherence to statutory scripture. We would in effect nullify that right. This petition is challenging the statutory application that I, the first respondent, undertook in the elections of 8th of August 2017. This being elevated so that maybe relief can be found to constitutional breaches. We submit that on the evidence that they have tendered, the arguments they have been going around is on the form, the mechanics of the election. And therefore, this court, in this case, there's no need for it to go back to its decision in the Raila case 2013 as to whether there is a conflict between their constitution and Section 83. In fact, in the written submissions of the respondents, at paragraph 245, the petitioner's submissions, they argue this way. The argument, therefore, that an irregularity such as non-compliance with the constitution of state or irregularity must answer to the question, did the irregularity or non-compliance affect the result, is a misnomer and a complete distortion of Section 83 of the Constitution, which was enacted to give effect to Article 81 and 86 of the Constitution, and not restrict its interpretation and effect. An election that was done in breach of the law, and in particular the Constitution, or in this case, that is in their case, in breach of the Section 39 of the Elections Act, and Section 44 is incurable. That is where their case is. Statutory enforcement that the first respondent, did he comply or did not comply? Our submission is compliance was substantial. There's judicial precedent that you cannot have 100% election. So the errors, administrative, that will emerge if there is close scrutiny cannot allow this court to depart or to render Section 83 void. They have not pleaded for you to avoid it, and therefore it does not arise. It is an afterthought. I submit that, therefore, Section 83 is not an issue in this petition. Maybe at another forum, on another occasion. Thank you very much.
Thank you very much. Who is next?
I thank the Honorable Chief Justice. My name is Peter Wanyama. I'll make some submissions on behalf of the second respondent. My Lord, there's an affidavit by Wanyonyi Chebukati, which was sworn on 24th of August 2017. This affidavit is very important. Interestingly, the respondents have not, the petitioners have not made reference to this affidavit. Yet this affidavit contains a very, very important piece of evidence, the Form 34Bs. It is our critical submission, it's our key submission that these Form 34Bs are not forgeries. These Form 34Bs were downloaded by the chairperson of the commission. My other friend, Mr. Nyamundi, explained in detail the two methods of transmission. These results were sent electronically from the constituencies to the National Tallying Center, and also using the complementary mechanism. Now, if you examine this Form 34Bs, the originals of which are available for verification, the Form 34Bs are not forgeries at all. And we have availed these forms to the petitioners for purpose of verification. And our submission is that the result which will arise from this verification will not depart in any way from the results which were announced by the chairperson of the commission in accordance with his constitutional mandate on 11th of August 2017. My Lord, various allegations have been made against the chairperson of IEBC, but it's important to mention that the chairperson of IEBC fully complied with the legal framework for declaring the president of this, the president of elect in accordance with the provisions of section Article 138 of the Constitution. It's important to emphasize that the results which were declared on 11th of August 2017 show that Uhuru Kenyatta, in accordance with the affidavit of Chebukati, garnered 8,203,290,000 votes. These results were publicly availed to all the presidential candidates. They were subjected to some kind of verification. The Form 34C, which was used to declare these results, has been availed to this court, and it's a submission that if there are any errors in the Form 34C, which we deny expressly in this court, the validity of Form 34C cannot be questioned at all. It has also been submitted extensively by the petitioners. That the chairperson of the commission didn't follow the results pathways, which were in the Maina Kiai decision. So I just need to emphasize that Maina Kiai judgment. My Lord, if you examine the Maina Kiai judgment, which you have annexed in this, this first and second respondents' authorities, volume 2, this Maina Kiai judgment, as submitted by my friend, Mr. Paul Nyamundi, is expressed clear and unequivocal that the chairperson of the commission has no responsibility, has no powers whatsoever. In fact, if you look at the Court of Appeal judgment, it says, it uses very, very strong words. It says the chairperson of IEBC cannot correct. He cannot vary. He cannot alter. He cannot modify or adjust the results which have been submitted to him from the constituency tallying centers. That confirmation by the Court of Appeal is very, very critical insofar as the finality of this election results is concerned. So it is not true, as submitted by the petitioners, that the results which were forwarded from the constitutional tallying centers to the national tallying centers were subject to verification and confirmation by the chairperson of IEBC. So that submission is a falsehood, and we have annexed the judgment from the Court of Appeal for this court to examine when you retire. Now, I need to emphasize a fundamental point here. You know, if you look at this petition, the petitioners, it's not clear because it looks like it's a mutating petition. It's not very clear whether the petitioners are saying that the technology adopted by the commission actually failed. My other friend, Paul Mangi, says the technology didn't fail. But the submissions by the other councils, including Mr. Oluoch, says the technology failed. So is this petition a petition which meets the constitutional threshold for precision? What is the exact allegation before this court against the chairperson of IEBC insofar as the conduct of these elections is concerned? My Lord, the chairperson of IEBC is an advocate of the High Court with 32 years experience in the legal profession. He fully complied with all the requirements laid down in the Constitution insofar as the declaration of the results were concerned. And therefore, it's absolutely important that the petitioners come out clearly to demonstrate what is really their complaint. Secondly, from the submissions by the petitioners, they have said that there was substantial non-compliance with the electoral laws. But if you examine again the submissions which were made, it's not very, very clear whether it is the cumulative minor errors which they are using as a ground to vitiate this election, because it is not actually clear. So we are submitting that for legal and constitutional purposes, you cannot, as the Supreme Court, interfere with these results if there is no proof of substantial non-compliance with the electoral law. Minor non-compliance, insignificant non-compliance, electoral malpractice, which are minor in nature, is not in accordance with the jurisprudence of this court a ground to set aside the decision to declare Uhuru Kenyatta as the President of the Republic of Kenya. So that's very, very significant insofar as the second respondent is concerned. More importantly, the second respondent in his affidavit, he has explained clearly that in terms of the compliance on the requirements of transparency and accountability, the agents of the petitioners were given opportunity to participate in the electoral process which happened at Bomas of Kenya. However, in the course of the transmission of these results, and we've seen the controversies, some of them are saying that those results which were appearing on the screen are actually final results. In the context of that controversy and the allegation which they made that the system had been hacked, they walked away. So if you examine the Form 34C, which you have annexed to the supporting affidavit of, to the replying affidavit of Mr. Chebukati, it is expressed clear that they never signed that form. The chairperson of IEBC, in accordance with that affidavit, made available all the Form 34Bs which he received from the constituencies for verification. These Form 34Bs were available in a portal outside the TV screen. All they needed to do was to access the computer, download these forms, and then make a determination, which they failed to do. So it's absolutely important to emphasize that the Constitution, that this election was carried out strictly in accordance with the requirements of transparency, and they were given opportunity to really participate in the final process of the declaration of the results. And more significantly, it is important to emphasize that contrary to the submissions by the petitioners, the chairperson of IEBC and the results pathways which were explained by my colleague, Mr. Nyamondi, the results pathways which were laid down by law, the chairperson of IEBC has no role whatsoever in Form 34As. So in the submissions by my learned friend, Mr. Otiendo, he was talking about the chairperson of IEBC looking at Form 34As. It is very, very clear, beyond doubt, that the results which were announced at the constituency level are the final results. So once these results are forwarded to the center, the National Tallying Center, the chairperson of IEBC has no responsibility whatsoever. So any nexus between the chairperson and of the commission and the Form 34As is a nexus which cannot meet the legal and the constitutional threshold. So in terms of the requirements of transparency, in terms of the requirements of compliance with the Constitution, the chairperson of IEBC fully complied with us, and therefore there can be no doubt whatsoever that these elections were conducted in a free and fair manner, that these elections meet both the quantitative and the qualitative threshold as laid down in the Constitution. And more significantly, if there are any errors in the Form 34As, this is really significant, my lord. If there are any errors in the Form 34As, the Court of Appeal said those errors can only be cured by an election court. The chairperson of IEBC cannot examine the forms with a view of correcting those errors. So what he did in declaring Uhuru Kenyatta as the president-elect was really an act that meets the legal and constitutional requirements which have been laid down. So it's absolutely important to emphasize that insofar as the second respondent's role is concerned, there is no nexus which the petitioners have proved of any breaches, whether minor or major, of the Constitution. There's no proof whatsoever that the chairperson of IEBC committed an electoral offense. That's a very serious allegation that they made, that the chairperson of IEBC committed an electoral offense. There's no proof of that. They must produce evidence. This is a court of record. This is not a court of supposition and assumptions. It's not a court of speculation. They must produce express and clear evidence that the chairperson of IEBC committed an electoral offense. The question on whether the commission should have barred the third respondent or cited the third respondent for the breach of the code of conduct is a question which evidence has shown, in accordance with the affidavit of the chairperson, that he acted upon and wrote a letter to the director of public prosecution asking for the matter to be taken care of in accordance with our criminal justice processes. So there's no proof whatsoever that links the chairperson to that particular issue, and we are submitting that he discharged his responsibility in accordance with the law. But the petitioners have not submitted any evidence at all. The evidence which they have submitted is not stubborn. The evidence is not substantial. As I wind up, the evidence is not real. The evidence is not weighty. And the evidence is not meaningful for purposes of interfering with the weighty decision of which was made by an independent constitutional commission. So with that, I will hand the microphone to my hand friend.
My lords and your ladyship, I come at the very tail end, and my approach will be, number one, to respond to some of the issues that have been raised in submission by the petitioners, and to point you in the direction of the authorities and our submissions. And if your lordships and your ladyships grant me latitude, let me start by characterizing the pleadings before you. You will note, number one, that the pleadings before you suffer from lack of focus and particularity. Number two, you will note that if one was a legal Puritan, the main affidavit by the Honorable Raila Amolo Odinga is actually a defective affidavit. My learned teacher, Feroz Naroji, is here. You cannot start an affidavit with "we." I'm simply characterizing that affidavit. Number two, you will note that the affidavits offend Order 19, Rule 1 of the Civil Procedure Rules. The affidavits are full of hearsay. And I want to submit that Article 159 is the refuge of those who are on a fishing expedition. I'm inviting your lordships and your ladyships to examine those affidavits to their full effect. Number two, I want to be in a position to characterize what animated the petitioners to file this petition. And I'm submitting to you that this petition is an afterthought. I don't have enough copies, but I will take you, if you permit me, to the foundational reason given by the principles of the political coalition called NASA, and read on the 15th of August by the Honorable Raila Amolo Odinga. This is what the Honorable Raila Amolo Odinga read. We had said we will not go to court, but with the raid on civil society and determination to silence all voices that could redress legal, like AFRICOG and Kenya human rights, we have now decided to move to court. But the pièce de résistance is this. Our decision to go to court constitutes a second chance for the Supreme Court to use this to redeem itself. That is the basis upon which I'm locating my case and justifying why this particular case is here.
Just a minute, Mr. Lumumba. Yes, Mr. Orengo?
I'm just saying this report is not a rostrum, so speechifying and oration. He should tell us where that statement comes from and whether it was correct on record.
My Lord, this is a statement that is in the public
Yes, if
domain.
it's not on record, then it can't be part of it.
Mr. Orengo, you will notice that we have been very, very patient. Mr. Lumumba is looking at the clock. He has the minutes. As soon as, if he goes on a tangent, as soon as the time runs out, we'll ask him to sit down.
Absolutely.
Thank
And
you.
I'm not going on a tangent. So that your lordships and your ladyship, that is what animated this case, and that is the reason why the pleadings are the way they are. And if you look at the submissions that have been made, the first submission is made by the Honorable James Orengo. And the Honorable James Orengo refers you to Article 1 of the Constitution in response. He says that this petition is essentially a petition of the people of Kenya. We are submitting to you that this is a petition by two petitioners about an electoral result. And that therefore, when you are looking at this petition, the question to ask is whether your petitioners have satisfied the requirements of the law in proving their case. And we have demonstrated, the submissions have been made to demonstrate very clearly that there is no case that has been proven. My lords, you will note that in the submissions made by the Honorable Orengo, he submits that a number of votes that have been cast, and this is also shared by Paul Otiende Amolo, that out of the 15-odd million votes, only 23,000 of them are in doubt. My Lord, the maxim of law used to be de minimis non curat lex. Professor Juang taught me that, and he'll remember. Of small things, the law knows no cure. And I'm submitting to us that what we have here are petty grievances, administrative errors, and no court in the world has ever nullified a presidential election on the basis of what falls under the de minimis rule. The second presentation made to you is through the submission of my good friend Otiende Amolo, who brings to the table what he calls numerical and non-numerical issues. And Otiende, in his submission, says that this court should only focus on what he describes as the substantive. In other words, numbers do not matter in an election. My lords and your ladyship, what then matters in an election? What matters in an election is that individuals come and vote, and those votes are counted, and the voice, the will of the people is expressed in that way. My lord, I refer you to Article 86 of the Constitution, which says that at every election, the Independent Electoral Commission shall ensure that whatever voting method is used, the system is simple, accurate, verifiable. I'll not address you on those details. My good friend Otiende went into characterizing those. Who must verify? In whose eyes must they be simple? Madame CJ, as he then was in the case of Stanley Munga Githunguri, said, the test is the man in the Pangani bus, the ordinary man. What you are shown here, complete with Pythagoras' theorem, to tell us what the voting went, that is not what the test of the election is. The test is very simple. And we have demonstrated through our affidavits that are on record, which I invite you to look at to their full effect, that the system was simple. And I want to imagine that your lordships and your ladyships walked there yourselves. You are identified. You are given 6 ballots. You marked your preferred candidate. That is how simple it was. It does not require Pythagoras' theorem. My lord, after the Otiende had talked about given us the Pythagoras theorem, we had Okongo Omogeni's submissions. And Okongo Omogeni is my very good friend, and I love the submissions. They were in the nature of asking you to make prescriptions for law reform. That is not what you are here to do, and your lordship was very correct in telling him that that is at a forum to which he will belong after he's sworn in. In other words, what is before you is the determination of this petition on the basis of the prescription of the law, not on the basis of law reform issues. My good friend Mutaha Kangu was even more interesting and amusing. The thumb rule, never quote yourself. Mutaha Kangu, in his submission, quoted his book, quoted the writings of Waikwa. Those are opinions of individuals. Those are not things that should guide this court. And I'm submitting to us that on the evidence that has been adduced before you, and every allegation has indeed been answered blow by blow, the test is as found in Article 83 of the Constitution and the 2013 Raila case. It is noteworthy that you are referred to an 1872 English statute, that is the Ballot Act. I'm submitting to us that this court, and I want to submit to your lordship that when this court is sitting in determination of a presidential election, your jurisdiction is sui generis. Sui generis because you are sitting as a court of first and last instance. And therefore, when you exercise your jurisdiction, it is actually an insult to you to be asked to look at a statute that governs county elections in the United Kingdom. I'm submitting respectfully that you ignore such invitation. You are then taken by Otiende Amolo into what he described as the standard of proof. And this was also addressed by my learned friend Mutaha Kangu. And Mutaha Kangu made a very amazing proposition that the duty of the petitioner is to establish a prima facie case. And that once they establish a prima facie case, then the burden shifts. Nothing, respectfully, your lordships and your ladyships, can be further from the truth. The truth is, and this is the rule of the thumb, he who alleges must prove. And I'm submitting to you that your petitioners have made allegations, they have made many things, but they have not proven anything. My Lord, you are then taken to the case that has now been cited ad nauseum, the case of Maina Kiai. And it's instructive that when my good learned friend and my student Antonio Luoch showed the video stopped at a very convenient point where the late Musando said, and the chairman cannot vary the results. That's where it stopped. And the Honorable Justice Ojwang asked the question of what evidential value. If your Lordship look at the Evidence Act at section 106B, you will discover that the manner in which that video was introduced offends all rules of submission of evidence under our jurisdiction. I'm therefore submitting to us that in totality what you have is a litany of allegations that are literally standing on stilts and have only one fate. They fall when they have been faced by the weight of evidence that we have supplied. The other question that was raised is on the significance of elections. And this was Mutaha Kangu at Article 4 of the Constitution. He said that elections, and the Honorable Justice Mokin Wanjala was right and quick in saying that the lecture was Constitutional Law 101, in which he tried to educate us on what a republic is. But my submission is that in this petition, what we are grappling with is that the people of Kenya in their totality came out on the 8th day of August and expressed their will. This court should be very reluctant to overturn the will of the people of Kenya unless it can be demonstrated that indeed that will was subverted. And it has been demonstrated by the first respondent and the second respondent, the first and the second respondent, that indeed all the prescriptions of the law, and this, my Lord, when you retire, I do not want to belabor this issue. When you retire, the question that I invite you respectfully to ask, what is the litmus test? And my lords, when you look at our list of authorities, which has a number of authorities which I'll not take you through, it was filed on the 25th day of August, the year 2017, with a total of 30 authorities. The first authority is the Constitution. And what we invite your lordships and your ladyships to do is to look at the Constitution and ask the question, did this election satisfy the prescriptions of Article 81? And in my respectful submission, it did. Did it satisfy the prescriptions of Article 86? And in my respectful submission, it did. And once you've looked at the Constitution, the next question that you will ask yourselves, that when you look at the enabling legislation, did it satisfy those pieces of legislation? Did it satisfy the regulations? And the answer is that it did. And when you arrive at that finding, the only decision that I invite you to arrive at is that the people of the Republic of Kenya on the 8th day of August did express their will, and the first and second respondent did midwife. Remember, your lordships and your ladyships, ours is midwifery. We deliver a baby. That baby is alive and well. You are being asked to strangle the baby. Decline the invitation. Decline the invitation because the baby is alive and well. The next issue that we want to submit on as I draw to the conclusion, because I want to be very pointed, is to draw you to our own submissions. My Lord, I've always said that when one wants to submit for too long, it tells you that there is actually no case. That which is clear is stated in a very brief manner. My Lord, if you look at our own submissions, which submissions were filed, dated the 25th day of August this year, we used the submissions to address all the issues that are germane to this petition. And I want to draw your attention to pages 2 through to pages 3, paragraphs number 5. Paragraph number 5 is important because it captures the essence of our case and simply tells us that the election of a president is a process. It is not an event. And if you look at the totality of the process, you will discover that this process is a process that satisfied the requirements of the law. And we have demonstrated at the point of identification, at the point of result, the point of counting, the forms 34A, B, C, and D, up to the transmission, and we have demonstrated beyond peradventure that indeed this was an election that complied with the law. My Lord, I also want us to look at in our own list of authorities on pages 8 through to page 11. You will discover that those are the pages that deal with the entire process. And it is worth noting that your petitioners, through their agents or through their sympathizers, have before this date litigated every aspect of the election. That is in the public domain. Every aspect has been litigated, including the procurement of ballot papers, including submission, including the transmission of results, so that as we come here, if one were to use the word res judicata loosely, I will not. I would say that these issues are res judicata, but I will not say that, knowing that your jurisdiction is sui generis. So the totality of our submissions, your lordships and your ladyships, is that we have demonstrated through the various affidavits that this petition is destitute of merit. And because it is destitute of merit, it should suffer only one fate, the fate of dismissal. But there are two things I want to say before I sit down. That when you look at your petitioners' written submissions, they suffer the same fate as all their pleadings. The rule of the thumb is that you don't use your submissions to introduce new evidence. Their submissions are used to introduce new evidence, thus offending all the rules that govern written submissions. In a nutshell, my lords and your ladyship, what you have before you in my respectful submission is a petition that is dead on arrival. What you have before you is a petition that is replete with speculation, is a petition that does not have the evidential weight that is worthy of overturning the election that was conducted by the first respondent and its chairman, the chairman of the IEBC. I therefore respectfully submit, on the basis of the submissions that have been made on our behalf, on the basis of the affidavits that have been filed, on the basis of the authorities that we have filed, on the basis of our written submissions, which you'll have the opportunity to read in their full flavor, to come to a finding that this petition is without merit and to dismiss it with costs to your respondents. Those are my respectful submissions. Unless your lordships and your ladyships want me to clarify anything, I beg to sit down.
Thank you, Mr. Lumumba. You were clear.
May God bless you. God bless you.
I think we still have some 6 minutes? According to the... but I can take the 6 minutes tomorrow if your lordships feel like...
No. Just finish it and we...
My lords, just to wrap up, allegations made remain allegations. In the matter before your lordships, allegations were first made to the public and to the media. Grave allegations. They were repeated in the petition, repeated in the affidavits in support. They remain allegations. Allegations have to be proved by concrete, admissible evidence. That is something that the petitioners have wholly failed to do. My lords, where there were some instances of something in the nature of evidence, has been wholly answered and demonstrated as having been incorrect information, untrue information through us when we were pointing out the correct factual situation in respect of each of those allegations. So really, there is absolutely nothing on the basis of which the petitioners can ask your lordships to stand in the way of the manner in which the Kenyan people exercised their sovereign power in electing the president-elect. I think we've come to the point where, my lords, we have to learn to accept the results. My lords, we have no doubts whatsoever, the first and second respondents, that when these reports that in your ruling you directed be done are in hand, the first and second respondents will be wholly vindicated by the numbers that they conducted elections in accordance with the Constitution, in accordance with the law, and the person who they declared the president-elect actually won elections with an overwhelming majority. My lord, the suggestion that there was any rigging is a myth, perhaps created by people who do not want to accept those results. And that is understandable, because the results of elections are always emotive. But the numbers, the evidence is there, my lord, and we will be wholly vindicated. Focusing on the transmission of the results, the will of the Kenyan people is in forms 34A and 34B. That's where you find it. And once you find, there's no challenge on those numbers. There's no attempt to challenge those numbers. All the firing, the firepower has been directed at the system. But even that system, there was nothing wrong with it. And once you get the report on that system and the information in it, you will see, my lords, that you will need to dismiss this petition so that the will of the Kenyan people can stand, because that is what they wanted. I thank you.
Thank you very much, Council. We have the third respondent and two amicus to submit. Then we will have maybe a rejoinder. There is the report we ordered that should be in by about 5 p.m. tomorrow, so that we are able to, on our own, do some work, and I believe some of you will need some time to do some work. We propose to start tomorrow at 11 with the counsel for the third respondents, then followed by the amicus. Oh, yes, an interested party, then amicus, and of course the rejoinder IVNM, by which time we hope the report will have come in. We'll adjourn for a few minutes for you to look at that report. But the report, we are not going to allow more than one counsel representing one party to respond to that report. So choose among yourselves. We will only allow 3 people. Amicus, you have no business. The interested parties, you have no business on that report. We will only allow 3 people, and we will give each of them 10 minutes to respond to that report only, and then we will finalize. So we start at 11 o'clock, go on up to about 4-ish, get the report, and then give you a few minutes to look at it. We also look at it, you submit, and we conclude.
Thank you.
I think that's okay.
Yes, it is.
Mr. Mwite, you should thank us for being very, very patient.
Yes, indeed. I was tempted. My colleagues here were prompting me to ask
It's okay. We have given you our time.
Yes.
We have given you your time because we didn't want to restrict any of you. We have given you your time to submit, and I believe you have submitted all that you wanted to submit.
All of us on this side
now,
of the
of course,
yeah,
for the...
we are appreciative.
Yeah, okay.
Yes.
Thank you very much.